पार्लियामेंट के कानून को आप इस तरह से स्टे नहीं कर सकते हैं। और माननीय सर्वोच्च न्यायालय ने सॉलिसिटर जनरल ऑफ इंडिया के बात को माना है और उन्होंने संशोधन को स्टे नहीं किया है। सिर्फ उन्होंने उनके 2 पॉइंट पे सॉलिसिटर जनरल के बात को रिकॉर्ड पे लेकर के और अगली तारीख 5 मई मुकर्रर कर दिया है और 5 मई से इस मामले की सुनवाई शुरू हो जाएगी।
सर, यथास्थिति की बात कहेगी, यथास्थिति को कैसे लिया जाए?
नहीं, यथास्थिति मैंने आपको बताया कि 2 मुद्दों पर कि जो काउंसिल में और बोर्ड में अपॉइंटमेंट का जो मामला है वो अगली तारीख तक जो स्टेटमेंट सॉलिसिटर जनरल ने दिया है कि कोई अपॉइंटमेंट नहीं होगा। और दूसरा जो है वक्फ व यूजर, तो माननीय सर्वोच्च न्यायालय ने अपने आदेश में लिखा है कि जो रजिस्टर्ड हैं और गैजेटेड हैं उसको गवर्नमेंट डी नोटिफाई नहीं करेगी अगले आदेश तक।
सर, आप कौन से क्लियर है सर, वक्फ बाय यूजर को डिनोटिफाई नहीं करेगी ना? मतलब
नहीं, वक्फ बाय नहीं, सिर्फ वही जो रजिस्टर्ड एंड गैजेटेड हैं।
सर, ये कोर्ट
हाँ बिल्कुल, ये ऑर्डर शीट में है। जो रजिस्टर्ड नहीं है, जो गैजेटेड नहीं है, उसको सरकार संशोधन कानून के हिसाब से डी नोटिफाई कर सकती है।
सर, आप किसके लिए अपीयर हुए थे?
मैं हिंदू सेना और हिंदू महासभा 2 हमारे एप्लीकेंट्स हैं, उनकी तरफ से मैं संशोधन के समर्थन में हाजिर हुआ हूँ।
नाम बता दीजिए।
वरुण कुमार सिन्हा, विष्णु गुप्ता के लिए और एक पवन अग्रवाल है उनके लिए, सतीश अग्रवाल। नहीं, आज की सुनवाई पूरी हो गई, अगली तारीख 5 मई की मुकर्रर हुई है। धन्यवाद।
All right. In fact, this were the reactions, of course, pouring in from court. You can see there. Just look at that. That's the scene outside court number 1. The sheer number of advocates shows you how many petitioners there are right now. Obviously, how much interest also there is in this case. But which is why the Supreme Court obviously has passed that order today, saying that let there just be 5 writ petitioners and their lawyers in the next hearing. A pretty practical order, would you say, Ashwini Dubey, AOR Supreme Court, if I can draw you in here? How do you react to the way the hearing went today and the interim order passed by the CJI today?
Thank you, Uday, for having me here. Uday, it's when a constitutionality of any act is challenged and there are very heavy petitioners.
Okay, we're also getting word now that the next date of the hearing will be the 5th of May. So that's what I just, had put out a short while back, that about 2 weeks' time will be given, and that's exactly what seems to have happened. 5th of May will be when the hearing now will take place. So, over 2 weeks, of course, given to the petitioners to have their time to file their reply, and then, of course, also, the prosecution to file their reply as well to what the petitioners have said. Yes, go ahead, Ashwin.
There are when there are heavy petitioners and heavy legal people with legal acumen appears before the court, they always raise some new points which needs to be heard. But it is very clear that the court has not passed any order which would be detrimental to the amendment of the Parliament. Supreme Court has to hear the matter on May 5th onwards, as you rightly pointed out, and the centre has been directed to file its response because ultimately stakeholder is the centre, the Union of India, because the law has been passed by the centre, by the Parliament and majority. Number 2, the Honorable Supreme Court has said that the no waqf by user properties will be notified until the next date of hearing, is the May 5th, or if hearing starts, it may go because the constitutionality has been challenged. The Honorable Supreme Court, being the custodian of the Constitution, has always a legitimate expectation from the Parliament to see that whether there is any arbitrariness in the law amendment passed by the Parliament, or it is in consonance with the Constitution. That litmus test has to be checked. Third, the Supreme Court has said that no appointment will be made to the Central Waqf Council or State Waqf Council until the next date of hearing. 3-4 days back, the act has been, the amendment has been notified by the President of India. So in any case, it would have taken time. So there is no nothing. Nobody was going to be, take a new position here. So that's another aspect. And the Honorable Supreme Court said situation on the ground might change if certain provisions of the law are not stayed. Now, another yesterday's observation, Uday bhai, if you see, the Honorable Supreme Court was also worried about the violence. Now, there are 2 important crucial points I would like to discuss, and my brother Manasvi Thopper, of course, is against the amendment of the I presume that amendment passed by the majority of the Parliament. One, There are three types of court exist in the country, as I have rightly said: the Supreme Court, the High Court, and the civil courts. The Constitution specifically says union judiciary, state judiciary, and subordinate courts. And any property dispute, Uday bhai, correct me if I am wrong, I would stand correct myself. Any property dispute, be it of the religious mutt, be it the Religious Endowment Act, be it the land allegedly acquired by any mutt or the mandir, will be dealt by the court of law. But here it was a unique case in the country itself where कोई अदालत नहीं, कोई दलील नहीं, बोर्ड और ट्रिब्यूनल का डिसीजन फाइनल होगा. Don't you think that we live in a country where the constitution is supreme, rule of law is supreme, then the matters of property dispute should be decided by the court itself. But the tribunal's decision was final and binding. Many my Muslim brothers calls me from Rajasthan and various parts कि भैया हमारी जमीन में वक्फ में चली गई है, कागज लेकर के जाते हैं और बोर्ड वाले देखते नहीं है. Just irony understand. So if the parliament says, look, this law was arbitrary and that the court of law competent to adjudicate the property dispute must be looked into, where the waqf which is claiming any ownership over the property has been rightly done, and if not, that should be returned back to the owner who is signing. माने there was a law, उदय भाई, माने reason to believe, there has to be reason to believe कि सुमित पीर का जो ऑफिस है वो वक्त का चला गया. Now Sumit Peer won't be having any right to go to the court. He has to go to the board, and the board will go to the tribunal. Tribunal would consist of the similar people of the same majority who would abide by the board decision, and कोई अदालत में दलील नहीं जाएगी. That definitely was need to be changed because 1950. और एक और बात उदय भाई, if देश धर्मनिरपेक्ष है तो कानून भी तो धर्मनिरपेक्ष होना चाहिए. Now another point. सेंटर कैन नॉट मेक एनी.
धर्म से याद है, अश्विनी डुबे छत्तीसगढ़ के वकील कहते हैं कि वी आर इन फेवर ऑफ द लेजिस्लेशन. द सुप्रीम कोर्ट हैज सेड देयर कुड बी सम हिंदूज हु आर अपोज्ड टू इट एज वेल.
Irony is this only. It's not a Hindu and Muslim. Center has to make a balance between two. If any, because the center cannot be biased for a particular religion. The institution, the state, and the judiciary has to go by what the people of the country, irrespective of their religion. That is why we are saying the state can't be religion specific. Political leader one can be religion speaking. So I think that the center was being represented to support the bill or the law which was passed by the parliament, क्योंकि states is center की ही duty. Now another point. Unified code for trust and trustees, charities and charitable institutions, charitable religious endowment, religious institution and law.